Well, I'd like to talk a little bit about intellectual property as it relates to drones. Now, there are three basic types of intellectual property that I'm going to be going over. These are patents, trademarks, and copyrights. Now, with respect to patents, there are two basic types of patents that relate to the drone field. Utility patents that protect the function of an item, and design patents that protect the shape of an item. Now, let me give you an example of a utility patent. For example, here we have a Parrot drone. We have some removable propeller protectors. So this would be the kind of thing, if Parrot was the first company to invent propeller protectors that snapped on to the side of a drone, they could get a utility patent on the function of those propeller protectors. Now, let's say that three-bladed propellers have been around for a number of years, but these had a particular shape. This would be something somebody could get a design patent on, where they protect the shape of the item. Now, design patents tend to be examined more rapidly by the U.S. Patent and Trademark Office. Utility patents tend to take longer to get examined because, quite frankly, they're much longer. And the prior art search for a utility patent, where the examiner has to go out and look at other patents that are similar to it, takes them a longer time than it does for a design patent. So basically, utility patents protect the function. Utility patents are, for most inventors, the best protection they can get over their invention, because if you can protect the function as opposed to the shape, you generally tend to get a stronger intellectual property portfolio. With utility patents, they're usually examined anywhere from 1.5 years to 2.5, 3.5 years after filing. The rapidity with which a utility patent is examined, as with a design patent, is how many types of patents are showing up, or how many patents are showing up in that particular art unit, divided by the number of examiners. So, for example, in software, you have a ton of drone-related software patent applications that are showing up every day. You have a limited number of examiners who are examining those, so software tends to take a longer time to be examined than, say, a simple mechanical invention, where there aren't quite so many applications showing up and there are quite a few examiners who are able to deal with it. As a confounding variable, you have the fact that many examiners at the U.S. Patent and Trademark Office are hired away by law firms. So frequently in the software area right now, you have a number of examiners who are being sought after by Apple and Microsoft and other companies like that. So sometimes you'll find yourself in the middle of the patent application and your examiner will be hired away and you'll get a new examiner. This is something of a painful experience, because then you have to educate a new examiner as to your patent application, why you think it should be allowed. On the design patent front, it appears that the mechanical engineers are not being hired away from the USPTO quite as quickly as the software engineers are, and so you have a much better chance of keeping both your design patent, because the design patents have to relate to the shape of an item, and your simple mechanical utility patents. You're much more likely to keep your examiner for the lifetime of your patent application and the prosecution thereof. Now, one thing to remember about patents is they have a limited life. So with utility patents, a utility patent is good for 20 years from the date of filing. Since I've already told you it's going to take a few years to get the utility patent application successfully prosecuted, most inventors end up with about 17 and a half years useful lifetime of their patent. And a lot of your inventors are going to freak out when they hear this, because they're going to say, well, my invention is way too valuable to possibly have only 17 years of protection on it. To these people, here are a couple things that you can say. First of all, over 50% of the money made in the United States retail market is made off inventions that are 2 years old or less. The second thing you can tell them is, with most inventions, you have pretty much 5 golden years to make money off your invention. If you've got a patent and you're not making money within 5 years, you probably never are. Now, there are exceptions to this. If you're the person who invented the first laptop computer, when that patent expires, you're bummed out because you had a patent that was probably making money right up to the last day of its life. But if you have an idea that's an improvement over somebody else's idea, odds are as soon as your product hits the market, you're going to have people who are going to be improving upon your ideas. So again, if you have an inventor who's freaking out about the length of time that their patent is good for, again, you can tell them 5 golden years, and over 50% of the money made is made off inventions that are 2 years old or less. With design patents are good for 14 years from the date of issue. So again, you get 14 years useful lifetime of your design patent, as opposed to utility patents that have 3 sets of maintenance fees due. For utility patents, maintenance or renewal fees are due at year 3.5, 7.5, and 11.5. For design patents, there are no maintenance fees due. So you pay that issue fee, you get your design patent, you have 14 years of protection. And again, especially with design patents, it's very rare that you find a design patent that's really making a lot of money by the time that design patent is ready to expire. Now, with utility patents, they tend to be the most expensive type of intellectual property people can apply for. And you have to file, when you file a utility patent application, you have to file an application with claims that fairly narrowly claim what you've actually invented. Now, a lot of inventors, they have an idea, but they don't really know exactly what the invention is going to completely comprise. And so they would much prefer to file a looser patent application that more broadly claims what their invention has to deal with. And so for these people, there's something called a provisional patent application. Now, a lot of people say, well, I've got a provisional patent, I'm protected. You're really not protected in the sense of having patent rights, because a provisional patent application is not really a patent. It's not examined. You don't either get it or not get it. It's an application that basically just sits at the U.S. Patent and Trademark Office for a year. Now, during the year that you're patent pending, you can do R&D, you can improve your invention, seek investment, try to get on Shark Tank, put it out on Kickstarter. You can try to sell your invention outright. But at the end of the year, you have to file a utility patent application that claims priority back to the provisional. And this is where a lot of your first-time inventors run into trouble, because they will try to file their own provisional, or they'll do it online, El Cheapo provisionalpatents.com. They can file something for 99 bucks and, I don't know, maybe the Ginsu knives or something like that. But they file a really poorly drafted provisional patent application, and later they try to claim priority back to it with a utility patent application. If the provisional is poorly drafted, the examiner can actually refuse to give you the priority date. And here you run into situations where the inventor goes out and publicly discloses their invention at a trade show. They get some positive response from people there. They quickly draft a provisional application after they publicly disclose their invention. The provisional application was very poorly written. They later file a utility patent application that claims priority back to the provisional, but the utility patent application has a filing date more than a year after they disclose their invention at a trade show. Well, if the examiner doesn't give them the priority date, they can actually have their own disclosure at the trade show count against them getting a utility patent. They can create their own prior art by publicly disclosing their invention more than a year before the utility patent filing date. And again, unless they can reach back and grab that provisional filing date, they can have their own public disclosure count against them. So that's something that you really have to be careful about if you're going to use provisionals. Got to be well written. You should really file your provisional before you publicly disclose, and then within a year of the provisional filing date, you've got to file that utility patent that effectively reaches back and claims priority from the provisional patent application. So the other thing that I'd like to talk about in terms of technology, we've gone over the drones, the various ways you have communication devices to direct the drones, but one very hot area right now are drone backpacks. Now, when we all started flying drones, we basically would keep them in their box and throw the box in our regular backpack and haul them around. Well, now we have specialized drone backpacks, and so let me get the Sky Controller out of the way. Here's one that just showed up from Lowepro, and this is a very rough, very tough backpack. You can carry this thing on a plane, drop it, and your drone's going to be fine. It's got a place on top for your controller. It has backpack straps so you can carry it comfortably. And when you open it up, you see it's got a place for your drone, a place for batteries, a place for extra equipment, things like that. And so essentially you can take the entire drone on your back just like it's a little knapsack. So drone backpacks are really taking off right now. They're getting better and better and being able to carry a wider and wider variety of drones. And speaking as somebody who's done quite a bit of hiking to get to places to fly my drones, these padded straps are really going to come in handy.